Discovery should be
Discovery.
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
This court hearing turns extremely heated as a sovereign citizen keeps trying to provoke the judge, and it ultimately doesn't work out in his favor. If you're not familiar, sovereign citizens are people who claim they can ignore or opt out of certain laws by arguing they aren't subject to them. The exchange is intense and dramatic from start to finish, with plenty of tense moments that keep it engaging to watch. Share your thoughts about the hearing, and if you enjoy this kind of courtroom breakdown content, be sure to like and subscribe. Let's get into it.
Already, Judge Torshio Fleischer, Assistant Public Defender, on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
It's going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No.
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Spoiler alert, he showed up at 3 o'clock even though he said he would arrive at 3:30, which immediately undermined his claim and put him in a bad light with the court. It suggests he understood the judge's authority despite trying to act otherwise. The judge is about to confront him over giving false information, which is taken very seriously in legal proceedings and can lead to contempt consequences. His actions come across as wasting the court's time, and it's clear this isn't a setting where games or misleading statements go over well. What do you think about his strategy here? From the outside, it doesn't look very smart to mislead the court, but share your take.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right. You understand at your arraignment, you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
I really want to understand what this guy is thinking. He gives misleading information to the judge, walks into court without a mask, insists the court has no jurisdiction, and argues the case should be dismissed because there's no injured party. It's a very confused legal strategy. Courts generally do have jurisdiction over matters brought before them, and many charges don't require a specific injured person, including offenses like fleeing or evading authorities. His arguments sound more like misunderstandings of legal theory than solid courtroom reasoning, and the approach doesn't seem to be helping his position. So far, it's not going in his favor. Let's continue.
Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
You're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them all tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
All Okay, you've already done that.
Is anyone else starting to feel a bit sorry for this guy? He's getting firmly corrected by the judge, and it's clear Judge Simpson has very little patience left for these kinds of sovereign citizen arguments. The defendant seems to be treating this like an informal preliminary discussion, but in reality he's out of his depth and doesn't appear to understand the legal standards involved. It's uncomfortable to watch because he keeps insisting on requirements that don't apply at this stage of the hearing. Instead of working with legal counsel, which is often available through public legal aid, he continues trying to argue complex legal points on his own, and the strategy doesn't seem effective. What do you think about his approach? Let's continue.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been denied.
I wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have discovery?
Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen.
Discovery.
Not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing.
What kind of jurisdiction here?
Personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
Do you think this guy is pretending not to understand, or is he genuinely confused? He keeps asking for a jurisdiction hearing, which is a proceeding where the court determines whether it has the authority to hear a case, and that's usually addressed right at the beginning if it's going to be challenged at all. Raising it late typically doesn't change much once the case is already moving forward. He seems to believe that simply demanding it will make everything stop, but court authority doesn't work that way. It feels like he may be repeating something he heard online rather than following solid legal guidance. Instead of speculating about his intelligence, it's fair to say his strategy appears misinformed and ineffective. Let me know what you think, and let's continue.
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step. And I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine. And then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date
So
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
just on the record, I'll put it on the record that I object. But under threat, duress, or coercion, again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed? Or I'm trying to figure out how to get the paper.
You can check out at the front counter.
Okay. Thanks.
I know this guy identifies as a sovereign citizen and seems pretty confused about how the legal system works, but what do you think about how Judge Simpson handled the situation? Was he too harsh or just being firm? The judge came across as blunt and clearly frustrated, but some viewers might see that as a necessary reality check given how the defendant was behaving in court. Instead of being prepared with proper legal counsel, the defendant tried to treat the hearing like a debate over personal rules, which didn't help his case. There's been a noticeable rise in people online promoting questionable legal theories and supposed loopholes, and that can lead to misunderstandings about real consequences. Courtrooms depend on respect, preparation, and accountability, and when those are missing, it slows everything down and wastes public resources. Share your thoughts on how the hearing was handled. Was the judge too tough or appropriately direct? And thanks for watching. Be sure to like and subscribe if you enjoy this kind of content.